Good morning, and may it please the court, your honors. My partner, Bryssa, Rodriquez, and I, Lance Belderol, will be representing Trinity Lutheran Church Incorporated today in this case. I will be speaking for 7 minutes, and we will reserve 5 minutes for the rebuttal. Now, the issue I will be addressing is whether conditioning government benefits on religious status violates the First Amendment when the state has no valid Establishment Clause concern. Now, Your Honor, it absolutely violates the Free Exercise Clause by going over the Free Establishment Clause, and we disagree with the lower court's ruling for that very reason. I respectfully request that you overturn the lower court's ruling for these two reasons. First, the scrap tire program does not violate the Establishment Clause if it is granted Trinity a grant. Instead, it violates the Free Exercise Clause by making government benefits conditional on religious status. And second, because of nonprofit corporation status, denial of a grant as establishment of a religion is void. Now, for the first argument, the Free Exercise Clause and the Establishment Clauses are not in conflict. They are complementary. They must be, as said in School District of Abington Township v. Schmepp, be read together in light of the single end in which they are designed to serve.
Counselor, why is that preferable over not having them separate clauses?
Well, having them separate just means that they're just purely there as standalone, but having them together means that there can be boundaries of which they can be used to their fullest realization, Your Honor.
Continue.
Now, the two parts of the religious clause, as said in Board of Education of Kyrios Joel Village, School District versus Rumit, speak with one voice on this point. Absent the most unusual circumstances, and one's religion ought not to affect one's legal rights or duties or benefits. Now, in the court case District of Abington Township v. Schmepp, it was a case ruling where a violation was found when the required activities encroached on both the Free Exercise Clause and the Establishment Clause of the First Amendment. Since the readings and recitations were essentially religious and ceremonies were intended by the state to be so, the state has effectively violated both the Free Exercise and Establishment Clauses by not following neutrality when dealing with these issues. Now, in the court case of Board of Education of Kyrios Joel Village School District v. Rumit, it was a case where New York's 1989 statute intentionally drew its boundaries in accordance with the boundaries of the village of Kyrios Joel, a religious enclave of Satmar Hasidim who practice a strict form of Judaism. Now, both of these cases have set forth a boundary of the Establishment Clause of when it goes into effect, when it's effectively going into the Free Exercise Clause. And Missouri's scrap tire program violates the basic principle of neutrality by singling out religious organizations for disfavored treatment based solely on their religious status.
Now, Counselor, did the state of Missouri send the Trinity Lutheran Church Incorporated a letter to that effect?
Yes, they did send a letter saying that they didn't receive the grant purely because they had a church in the name, or they believed it was a church based because of the church in the name. Now, even so, Missouri's scrap tire program should not be conditioned to benefiting non-religion over religion. This would in effect violate both the Free Exercise Clause, punishing Trinity for being a church. Now, to the second argument, there should be no argument that because of the nonprofit corporation status, Trinity Lutheran Church Incorporated should have been able to participate and gain the grant, especially when being 5th out of 45 applicants. To have the state apply the denial of the grant because this is a church and applying the Missouri Constitution's Article 1, Section 7 here is downright abusive and blatant. Now, please cross-apply Abington v. Schmepp 1963 and Missouri Constitution Article 1, Section 7, where it says, no money shall ever be taken from the public treasury directly or indirectly in aid of any church, section, or denomination of religion. By denying the grant to resurface the playground for the simple fact that there is the word church in the organization is blatant discrimination. Because there is a very noticeable difference when looking into the actual validity of the argument with Trinity Lutheran Church Incorporated not being able to gain a grant. This is especially true when seeing that they placed 5th out of 45 applicants, and the program awarded 14 other applicants besides them. The only way the state program will not be able to give the grant is with their own invalid argument of it going against the Free Exercise Clause, when really denial of it does so and the latter not. This goes to show that not only would the status of nonprofit corporation allow this organization to be given a grant from said program, but having denial of the grant because of affiliation with the church would adversely affect further proceedings dealing with very vague and incorrect uses of the definitions of corporation, separations of church, and establishment of religion.
Counselor, what problems have developed because of this loose interpretation?
Well, problems such as Problems such as corporations merely having the church in their name would mean that they would not be able to receive very much from the scrap tile program or any programs that prohibit gain of a grant based on their name.
And Counselor, according to your understanding, was the purpose of the grant to try to help the common good of the state?
Absolutely. The purpose of the grant was to do that because it does get rid of tires. And if they are keeping the tires from just letting them rot there and just letting them waste, then they are effectively wasting not only their grant, but wasting the availability of tires that they have.
So it would be your assertion that it doesn't really make a difference who got the received the material, as long as the material was received, and being ranked 5th out of 45 people, they should have been able to apply if it wasn't for being discriminated against, correct?
Yes, you are, yes.
Continue.
Now we pray that you overturn this unjust discrimination and overturn the lower court's ruling on this and fine for the Trinity Lutheran Church Incorporated.
Good morning, Chief Justice, and may it please the court. I, Bryssa Rodriquez, along with my partner, Belderol, will represent the petitioner, the Trinity Lutheran Church Incorporated, in the case before the court today. I will speak for 8 minutes. Please cross-apply all of my partner's arguments. Your Honor, we soundly and firmly disagree with the lower court's ruling. Funding a playground associated with a corporate church does not violate the Establishment Clause of the First Amendment. We respectfully request that you overturn the lower court's ruling for the following 2 main reasons. First, because of nonprofit corporation status, the denial of the grant demonstrates that while there cannot possibly be a violation of the Establishment Clause other than for the petitioner, there is also a violation of the 14th Amendment for blatant discrimination under the Equal Protection Clause. Second, the meaning of separation between church and the establishment of religion are not correctly applied to this case. Now, to my first point. Withholding the grant violates the Establishment Clause and it discriminates. The Establishment Clause prohibits not only government actions establishing, endorsing, supporting religious, but also for those that are handicapped, cross-applying Everson versus Board of Education in 1947. It read that the Establishment Clause requires that the state be neutral in its relations with groups and believers of knowledge.
Considering this idea of neutrality, what exactly is neutral?
Well, Your Honor, neutrality comes when in a scope of review in which the state does not favor non-religion over religion or religious over non-religious organizations.
Let me just theoretically ask. According to your assertions, then, a non-religious attitude could become a religion if it was demonstrated over a religious attitude, correct?
Your Honor, what we're trying to say here is that by the state denying the grant, but also being able to give grants to other communities just because they denied the grant to our corporation because of its name, they are indeed establishing a non-religion preference. Therefore, if there's any Establishment Clause violation today, it would be the state that is violating it, not the petitioner.
Continue.
Now, the clause goes beyond merely allowing the Missouri to give Trinity Lutheran Church a scrap tire grant. Under the clause's mandate that government neither advances nor inhibits religion, cross-applying Lemon versus Kurtzman in 1971. Now, cross-applying this case, it means that the state cannot deny Trinity Lutheran a grant on the sole basis that it is a church. Now, while the Lemon test has undergone restatement in recent years, cross-applying Agostini versus Felton in 1997, its core principles of even-handedness and have remained intact. Government may not engage in actions that have the primary effect of advancing or infringing religion. Not under the endorsement aspect of the test may government express endorsement or disapproval of religion.
Is it your assertion that, playground, tires on the playground advances religion at all?
No, Your Honor. It's simply a grant. And the fact that we're not looking at the religions portion of it, there seems to be proof that even under the neutrality scope, and of course, when it comes to whether or not it would be an advancement in religion, it's simply a school that happens to be associated with a corporation that has church in its name. So therefore not in any way improving or...
And this corporation has been in existence in Missouri as a nonprofit for over 60 years, correct?
Correct, Your Honor.
And the daycare center has been, before it was with this incorporation, was a nonprofit, and it's been with this corporation since 1985, correct?
Correct, Your Honor.
So this isn't a new phenomenon. And then the playground itself, who's the playground open to? Is it the entire community or just for church members?
Well, for the public, of course. And it's again, it's for the kids. It's not in any way setting forth standards when it comes to religion, or in any way saying that in order to enter the playground, you have to pray. So it's not in any way imposing religion. Instead, we see the state that is favoring a non-religious.
If anything, a fallback position could be that it would be for the common good of the community to have a safe playground, correct?
Yes, Your Honor. Okay, now, it also violates the Equal Protection Clause. Because the Equal Protection Clause limits how the government can use certain characteristics as basis for government action, the court has long held that the clause, despite its Civil War era origins, extends its protection far beyond race, which would apply to religion in this case. Now, most of the classification receive only racial basis review and are generally upheld, but where government distinction between groups involves an fundamental right like religion, the action receives strict scrutiny. Now, under the strict scrutiny standard, it would apply in this case because not only is there any kind of infraction against religion, but there is also discrimination. Now,
Counselor, excuse me just a moment. Now, could you tell me the difference between strict scrutiny and maybe a loose interpretation?
Well, Your Honor, under strict scrutiny, we're looking at the fact of whether or not there's a personal right that is drawn upon inherently, and whether there's suspect distinctions such as race, religion, or alienage that are in question. Now, because the state wrote in the letter when denying the grant that it was on the sole purpose that they would be infringing the Missouri Constitution, then it shows that strict scrutiny does apply in this case.
Okay, now, if you apply in strict scrutiny and your last statement, what was your last statement again?
Regarding our case? Or?
Yeah, no, regarding your answer. It was fascinating in the respect that you said something to the effect of the state said the only reason that they were not able to get the grant was because of religion.
Right. There was a letter, as my co-counsel explained, that was written as to why they denied the grant.
Now, being a little bit interested in history myself and having taught about nullification of 1832 in South Carolina, isn't this an example of a state trying to nullify a right from a federal government? Is that possible?
Yes, Your Honor, but it's an example of a state trying to nullify federal law. However, it is not possible because of the Supremacy Clause. The Supremacy Clause states that federal law is the law of the land, and that state constitution cannot go and surpass our federal constitution.
Okay, and that's because we're a federal republic, right?
Right, Your Honor, which means that if the state essentially tries to go against our constitution, they would essentially be taking their own argument out.
Okay, continue.
Now, going on to the violation of the Missouri Constitution argument that the state may try to come up with, they cannot in any way bring that argument. Why? Because looking at the Establishment Clause verbatim reads that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, which means that in actuality, the only person that would actually be able to violate the Establishment Clause would be no other than Congress. The state is not Congress, Your Honor. And going back to the question that you asked me a few minutes ago, the state cannot surpass federal power. Now, in McDaniel versus Patey, 1978, the court ruled that under the Free Exercise Clause, it prohibits the government from excluding individuals based on their religious status from public rights or opportunities otherwise generally available to all, which is exactly what happened in this case.
What law was that, Counselor?
It's a federal law, Your Honor. It's a federal case, Your Honor, in McDaniel versus Patey, 1978.
And the ruling was what again?
The Free Exercise Clause prohibits the government from excluding individuals based on their religion status.
And that's exactly what you and your co-counsel have been trying to say in front of the court today, isn't it?
Yes, Your Honor.
Okay, continue.
Now, cross-applying all of the arguments made by my co-counsel and the findings of the case of the Church of Leukemia Babalui versus the City of Hialeah, the Free Exercise Clause protects religious observers against unequal treatment. Not only has there been a violation of the 14th Amendment under the Equal Protection Clause, but there has also been an infringement of the First Amendment with a violation of the Free Exercise Clause. And of course, Your Honor, this is simple and blatant discrimination. By upholding the lower court's ruling, you would in effect violate the Establishment Clause by preferring non-religion over religion and allowing for discrimination to continue. So, Counselor, in a summary type of question here, I believe the question posed today was, did this by giving a grant, does it violate the Establishment Clause? And it's your takeaway that it does violate the Establishment Clause, but not from
from the Trinity Lutheran Church Incorporated. It's from the state of Missouri.
Right, Your Honor. Answering the question, by giving a grant to the Trinity Lutheran Corporation, you wouldn't be violating the Establishment Clause. On the contrary, by not giving it, you would be violating it because it's on a basis of religion, therefore establishing non-religion preference over religion.
So the only way that you could violate it is the way they did it then, correct?
Yes, Your Honor.
Okay, so that needs to be overturned.
Yes, Your Honor. Thank you.